In January 2025, the Sackler family agreed to pay $7.4 billion to settle claims related to OxyContin and the opioid epidemic. The settlement was described by attorneys general across multiple states as historic. It was, by any measure, one of the largest civil settlements in the history of American public health litigation. $7.4 billion. The money would go to addiction treatment programs, to state governments, to the communities that had spent 20 years watching their residents die. No member of the Sackler family was charged with a crime. The family, which had withdrawn more than $10 billion from Purdue Pharma in the years before the bankruptcy, remained worth approximately $11 billion after the settlement. The Sackler name has been removed from the Metropolitan Museum of Art in New York, from the Louvre in Paris, from the Tate in London, from the Guggenheim, from Tufts Medical School, from universities and hospitals and cultural institutions across 3 continents. The name is gone. The money is not. This is the story of 3 brothers from Brooklyn who built a pharmaceutical empire, of the drug they created that killed approximately 500,000 Americans, of the $10 billion they moved out of the company before the lawsuits arrived, and of the legal architecture they constructed to ensure that none of them would ever face criminal prosecution. It is also the story of how the American legal system, applied to a family with the resources and the foresight to structure their affairs correctly, produced exactly the outcome the system was designed to prevent: accountability without consequences, settlement without admission, justice without anyone going to prison. Arthur, Mortimer, and Raymond Sackler were the sons of Isaac and Sophie Sackler, Jewish immigrants from Poland who had settled in Brooklyn in the early 20th century. The family was not wealthy. Isaac Sackler ran a grocery store that failed during the Depression, and the circumstances of the family's early years were modest enough that all 3 brothers worked to help support the household while pursuing their educations. All 3 became physicians. This was an achievement of a specific kind, the children of immigrants using education as the mechanism of transformation that the American immigrant narrative promises, and that the Depression generation treated as an article of faith. The Sackler brothers were, in this foundational sense, a story about aspiration and effort, and the specific ambition of people who grew up with little and intended to acquire more. Arthur was the eldest and in many respects the most consequential, not for what he did at Purdue Pharma, which he sold before OxyContin existed, but for the model he established that his brothers would later use. Arthur Sackler became, in the 1950s and 1960s, one of the most influential figures in pharmaceutical marketing in America. He was a psychiatrist who had gone into advertising, specifically pharmaceutical advertising, and who developed the techniques that would define how drug companies sold their products to physicians for the next half-century. Before Arthur Sackler, pharmaceutical marketing was primarily conducted through scientific journals and through sales representatives who presented clinical data to doctors. Arthur Sackler professionalized the craft of selling medicine. He understood that physicians, like other human beings, made decisions based on social proof, on authority, on the sense that a treatment was widely used and endorsed by respected colleagues. He built campaigns that used all of these mechanisms systematically. He marketed Valium, the benzodiazepine tranquilizer that became one of the most widely prescribed drugs in America in the 1960s and 1970s. He helped make it the first drug to exceed $100 million in annual sales. The campaign that achieved this emphasized Valium's safety and versatility, its applicability to the specific stresses of modern American life, and the frequency with which respected physicians were prescribing it. The campaign worked. Valium became culturally embedded in American life in ways that its predecessor drugs had not been. It also became a drug that millions of Americans were dependent on, that was difficult to stop taking, and that was eventually recognized as carrying significant risks of addiction and withdrawal that the marketing had minimized. Arthur Sackler died in 1987, before OxyContin existed, before Purdue Pharma became what it became. His estate sold his shares of Purdue to his brothers, and the proceeds went to the Arthur M. Sackler Foundation, which funded the Sackler Galleries at the Smithsonian and at Harvard and at a dozen other institutions that would later have to decide what to do with the name. He is not legally part of the OxyContin story. His estate settled claims separately, and for significantly less than the main settlement. His name, which is the name on the oldest and most prestigious of the Sackler cultural endowments, has not been removed from all of them, because the legal situation is different for Arthur's side of the family than for Mortimer and Raymond's. This distinction between Arthur's branch and the OxyContin branches is real in a legal sense. In a moral sense, it is more complicated because the marketing techniques that Arthur perfected are the techniques that were applied to OxyContin. The template was his, the application was his brother's. Purdue Frederick Company, which became Purdue Pharma, had been founded in 1892 and acquired by the Sackler brothers in 1952. Under Arthur's influence, the company developed a reputation for pharmaceutical marketing innovation. Under Mortimer and Raymond's management after Arthur's death, the company began developing the product that would define the family's legacy. OxyContin was approved by the FDA in December 1995. It was a controlled-release formulation of oxycodone, an opioid painkiller, designed to provide 12 hours of pain relief from a single tablet. The controlled-release mechanism was, Purdue claimed, a significant safety innovation. By releasing the drug slowly over 12 hours rather than all at once, it would reduce the euphoric rush that made immediate-release opioids attractive to people seeking a high, and would therefore be safer and less prone to misuse. This claim was central to the FDA's approval and to the marketing campaign that followed. OxyContin was presented to physicians as a safer opioid, one that could be prescribed more broadly than traditional narcotics because its design made it less addictive. The claim was false. The controlled release mechanism did reduce the immediate release rush in its intended form. What it did not prevent was the simple modification that anyone seeking opioids for recreational use would quickly discover. Crush the tablet, and you destroy the controlled release mechanism, releasing the full opioid dose immediately. The reformulation that actually addressed this problem was not implemented until 2010, 15 years after OxyContin's introduction, long after the addiction patterns were established. More significantly, the claim that OxyContin was meaningfully less addictive than other opioids was not supported by the clinical evidence available at the time of its approval, and Purdue's representatives knew this. Internal documents that emerged in litigation showed that the company was aware that its drug was being misused, that physicians were prescribing it for conditions and in quantities that exceeded the clinical evidence for its safety, and that the rates of addiction among patients were higher than the marketing implied. The sales force did not tell physicians this. They told physicians that OxyContin was less addictive, that fewer than 1% of patients who took it as directed would develop addiction, a figure derived from a brief letter in a medical journal that specifically did not address long-term use. They brought patients into doctors' offices to describe how OxyContin had transformed their lives. They distributed marketing materials, funded continuing medical education programs, and cultivated the key opinion leaders whose endorsements shaped prescribing behavior across the country. The techniques were Arthur Sackler's techniques, applied to a drug that was not what it was claimed to be. Between 1996 and 2001, Purdue increased its sales force from approximately 318 representatives to approximately 671. Sales of OxyContin grew from approximately $48 million in 1996 to approximately $1.1 billion in 2000. The growth was not the result of a newly identified medical need. It was the result of a marketing campaign that encouraged physicians to prescribe opioids more broadly than the clinical evidence supported, in the specific communities that later showed the highest rates of addiction and overdose: the Appalachian communities of West Virginia and Kentucky, the rural communities of New England, the suburban communities of Ohio and Pennsylvania, places where legitimate chronic pain was common, where physicians trusted the information they were given, and where the economic and social conditions that make addiction harder to escape were already present. The specific mechanism by which OxyContin spread through American communities deserves more than a summary, because the mechanism was not a market accident. It was designed. Purdue's sales force was organized around a data-driven targeting system that identified the physicians writing the most prescriptions for competing opioids and concentrated attention on them. The company purchased prescription data from IMS Health, a data broker that collects information about what medications are prescribed at what rates by which physicians. This data told Purdue where the highest prescribing physicians were and what they were prescribing. The sales representatives who called on those physicians came with specific tools: starter packs of OxyContin that could be dispensed to patients for free, patient testimonial videos showing people whose pain had been transformed by OxyContin, continuing medical education programs funded by Purdue that presented opioid prescribing in terms favorable to broad use, and a compensation structure that rewarded the sales representatives based on prescription growth in their territories. The representatives were trained to use a specific framing for the addiction question. If a physician raised concerns about addiction risk, the representative was trained to say that fewer than 1% of patients who took OxyContin as directed developed addiction. The 1% figure came from a letter published in the New England Journal of Medicine in 1980, a 5-sentence letter by 2 researchers who had observed hospital patients given opioids for pain management over a short period. The letter was not a study of long-term outpatient opioid use. It said nothing about the addiction risk of prescribing opioids to people with chronic pain over months or years. The 1% figure was nevertheless deployed systematically by a sales force that had been trained to present it as settled science. Internal documents that emerged in litigation showed that the company was aware that the figure was being used in a context for which it was not appropriate, and that some employees had raised concerns about this. The concerns did not change the training. The physicians who prescribed OxyContin in many cases were not acting in bad faith. They were presented with information that looked like clinical evidence by representatives who had been trained in how to present it. The marketing created a reasonable-seeming case for broad opioid prescribing that the actual clinical evidence did not support, and the physicians who were persuaded by that case were responding to what they had been told. The patients who received the prescriptions were told they were getting a safe medication that would manage their pain with low addiction risk. The patients in the communities that were most heavily marketed were, in many cases, people dealing with legitimate chronic pain from physical labor, from injuries, from the ordinary accumulation of damage that certain kinds of work inflict over decades. They were given an opioid by a physician they trusted, and they became addicted to it, and when prescription monitoring programs eventually made OxyContin harder to obtain, they turned to whatever was available. The community in Mingo County, West Virginia, that received enough OxyContin pills between 2008 and 2012 to supply every man, woman and child in the county with more than 1,000 pills per year, was not a community with an unusual pre-existing addiction profile. It was a community that had been targeted by a sales force with a product that did what opioids do. The 2007 guilty plea by Purdue Pharma was the first moment at which the legal system acknowledged what the company had done. Purdue Pharma pleaded guilty in federal court to misbranding OxyContin, admitting that it had misled doctors and patients about the drug's addiction risks. The company paid $634 million in fines. 3 executives were convicted. The company's top lawyer, its chief medical officer, and its chief executive, all of whom had been with the company during the relevant period. None of them were members of the Sackler family. The Department of Justice handled the case as a corporate matter rather than a personal one. The Sacklers, as owners and board members, escaped individual prosecution. Critics later called the plea deal a turning point in American corporate law, proof that a company could commit a crime without sending any of its owners to prison. The $634 million was described by the prosecutors, who negotiated it as a significant accountability measure. It was also, by the time the plea was entered, approximately 1 year's revenue for Purdue. The company continued to operate. OxyContin continued to be prescribed. The sales force continued to market the drug. Richard Sackler, who had been the company's president and who had driven the OxyContin marketing campaign with a personal intensity that internal documents and emails would later make visible, sent an email shortly after OxyContin's launch that described what he expected. He predicted that there would be a blizzard of prescriptions and described what the company should say when the inevitable criticism of opioid prescribing arrived. When that criticism arrived, in the form of lawsuits and congressional investigations and public health data that was becoming impossible to ignore, the company's response was the response Sackler had anticipated. OxyContin was not the problem. The abusers were the problem. The addiction was the fault of the people who became addicted, not the product they had been prescribed by physicians who had been told it was safe. This framing, which blamed the victims of a marketing campaign for being victimized by it, was the company's consistent public position for over a decade. The 2007 guilty plea did not end Purdue's engagement with aggressive marketing. It modified it, and the modification was assisted by a consulting firm whose involvement in the opioid crisis was not publicly known until a 2021 investigation by the New York Times. McKinsey & Company, the management consulting firm, was hired by Purdue Pharma after the 2007 guilty plea to help revive OxyContin sales, which had declined following the negative attention from the federal case. McKinsey's work for Purdue has been documented in materials produced in litigation and in a 2021 congressional investigation. The firm advised Purdue on strategies to increase OxyContin prescriptions, including strategies that the subsequent reporting described as focused on the highest prescribing physicians and on approaches that would maximize the number of pills dispensed. In one document that emerged in litigation, McKinsey proposed that Purdue consider paying pharmacies a rebate for each customer who overdosed on OxyContin, as a way of incentivizing pharmacies to continue stocking the drug, despite concerns about its use. The proposal was, according to McKinsey, never implemented. The fact that it was proposed at all was described by the New York Times as revealing about the firm's approach to the engagement. McKinsey settled with state attorneys general for approximately $600 million in 2021 over its work for opioid companies. The settlement did not require an admission of wrongdoing. The settlement was announced the same week that McKinsey was advising multiple governments on their COVID-19 responses. The firm that had helped design the marketing strategy that contributed to a public health emergency was simultaneously advising governments on how to manage a different public health emergency. This is not presented here as a conspiracy. It is presented as a description of how institutions that have caused significant harm operate within a system that has no mechanism to exclude them from future engagement, as long as they settle the claims and continue to function. The transfer of money out of Purdue Pharma before the bankruptcy is the detail that the settlement negotiations produced evidence of, and that the legal structure of the settlement was designed to accommodate. Members of the Sackler family withdrew more than $10 billion from Purdue Pharma, and put the money in family trusts as the company faced legal challenges related to its role in the opioid epidemic, according to court documents. Much of that money was transferred out of Purdue between 2008 and 2019, including around $11 billion withdrawn in the decade before bankruptcy, some of which was moved offshore. The mechanism of the transfer was legal, in the specific sense that each individual transaction was a distribution from a company to its owners, the kind of distribution that companies make to their shareholders regularly. The question that the state's attorneys general raised, and that the bankruptcy court considered, was whether the transfers, taken together, constituted a fraudulent transfer, a systematic movement of assets out of a company facing foreseeable legal liability, timed to place those assets beyond the reach of future creditors. Connecticut's Attorney General filed suit specifically alleging that the transfers were fraudulent, that the family had moved money out of Purdue with knowledge that the company was facing liabilities that would eventually exceed its remaining assets. The bankruptcy proceedings produced a settlement that addressed this question by paying the states enough money to resolve their claims without requiring a court to actually rule on whether the transfers were fraudulent. The settlement was $7.4 billion. The transfers had been, by the court documents accounting, approximately $10 billion. The family kept the difference. The bankruptcy proceedings produced a legal question that went to the United States Supreme Court. Could a corporate bankruptcy settlement shield non-bankrupt individuals from future civil lawsuits? Purdue Pharma filed for bankruptcy in September 2019. The Sackler family members had not filed for bankruptcy themselves. They were solvent, wealthy individuals who were not debtors in the bankruptcy proceeding. But the family made personal immunity from future civil lawsuits a condition of any settlement they would agree to. Without that immunity, they would not contribute to the settlement fund. Without their contribution, the settlement could not reach the amounts the states were seeking. The bankruptcy court approved a settlement that included this immunity in 2021. Several states challenged it. The challenge reached the Supreme Court. In August 2024, the US Supreme Court rejected that plan, ruling that non-bankrupt individuals cannot receive immunity through a corporate bankruptcy case. The ruling was a significant legal statement about the limits of bankruptcy protection. It was also, in practical terms, a negotiating setback that sent the Sacklers back to the table. They returned, and in January 2025 agreed to the $7.4 billion settlement that resolved the claims. The settlement did not include immunity from criminal prosecution. But by January 2025, the statute of limitations on most of the relevant conduct had expired. The window for criminal charges related to the most egregious period of the marketing campaign had closed. The bankruptcy proceedings had lasted 5 years, 5 years during which the statute of limitations continued to run. Whether the duration of the proceedings was itself a factor in the family's strategic calculation is a question the settlement terms do not address. The specific legal strategy that the Sacklers employed in the bankruptcy proceedings is worth examining in detail, because it represents a novel use of the bankruptcy system that legal scholars and policy advocates have described as a template that other wealthy defendants may seek to use in future litigation. The strategy, which lawyers have described as the Texas two-step, and which the Sacklers employed in a modified form, involves using a corporate bankruptcy to resolve claims against wealthy individuals who are not themselves bankrupt. Purdue Pharma filed for Chapter 11 bankruptcy protection in September 2019. The Sackler family members had not filed for bankruptcy. They were, by the court documents accounting, collectively worth approximately $11 billion. They were solvent individuals with very substantial assets. The family's condition for participating in a settlement was that the bankruptcy proceedings produce a legal release protecting them from future civil claims. If claimants could not sue them personally, they would contribute to the settlement fund. If claimants retained the right to sue them personally, they would not. The legal theory underlying this condition was that the bankruptcy court had the authority to grant this protection as part of a reorganization plan, even to parties who were not themselves bankrupt, as long as those parties were contributing substantially to the reorganization. This theory was contested, had never been definitively resolved by any appellate court, and was the subject of significant academic and legal debate. The bankruptcy court approved the settlement and the accompanying immunity. States challenged it. The Second Circuit upheld it. The Supreme Court, in an 8-1 decision in June 2024, struck it down. The majority opinion written by Justice Neil Gorsuch said the bankruptcy code does not permit releases of this kind for non-debtors. The dissent, written by Justice Brett Kavanaugh and joined by Justice Sonia Sotomayor in part, argued that the majority's ruling would destroy the settlement and leave the claimants worse off. The outcome vindicated the state's legal theory. It also practically required a new round of negotiations that produced the January 2025 settlement of $7.4 billion, approximately $1.4 billion more than the previous version. The additional $1.4 billion was the cost of the Supreme Court ruling to the Sacklers. The Supreme Court ruling did not produce criminal charges. It did not produce a full financial accounting. It did not claw back the $10 billion transferred before the bankruptcy. It produced $1.4 billion of additional civil settlement. For a family worth $11 billion, the additional $1.4 billion was approximately 12% of their net worth. The communities affected by OxyContin received in total a settlement that represents approximately 1/5 of what the family extracted from the company that produced the crisis. Nan Goldin had been prescribed OxyContin after wrist surgery in 2014. She became addicted. She went to rehabilitation. She recovered. And then, in 2017, she began organizing protests at museums that bore the Sackler name. Goldin was a photographer of international reputation, known for her intimate documentary work, and the museum world that the Sacklers had spent decades cultivating through philanthropy was a world in which her standing was significant. When she organized a die-in at the Guggenheim, lying on the floor under the museum's rotunda with fake pill bottles and signs reading "prescription pills kill," it was not an outsider's protest. It was an insider's protest, conducted by someone the museum world could not easily dismiss. She founded an organization called PAIN, Prescription Addiction Intervention Now, which coordinated protests at cultural institutions across the United States and Europe. The protests followed a consistent strategy: gather inside the museum, make noise, make the connection between the Sackler name on the wall and the bodies in the community visible, leave pill bottles in the fountains and on the floors, film everything. The Louvre removed the Sackler name in 2019. The Tate removed it. The Serpentine removed it. The Guggenheim removed it. The Metropolitan Museum of Art announced in December 2021 that the Sackler name would be removed from its galleries, including the Temple of Dender wing that had carried the name since the 1970s. The name came down from the walls. The money that had purchased the naming rights remained in the family trusts that the transfers had filled before the lawsuits arrived. The museums that removed the Sackler name did not return the donations that had accompanied it. The donations were spent. The endowments they had funded continued to fund programming. The name was removed. The benefit remained. This is, in a precise sense, the structure that the philanthropy strategy had always implied. The donation purchases the name. The name purchases the association. If the association becomes toxic, The institution can remove the name and retain the endowment. The family's money has done its work. The name's work is over. The institutions that accepted Sackler donations over 4 decades were not acting in bad faith. Most of them had no reason, at the time of the donations, to anticipate the scale of the OxyContin catastrophe or the legal proceedings that would follow. Philanthropy from pharmaceutical families was not, in the 1990s and early 2000s, considered a category requiring special scrutiny. What the Sackler philanthropy did accomplish, across the years when it was operating without controversy, was the construction of a set of relationships and associations that made the family significantly harder to prosecute. The Sackler wing at the Metropolitan Museum in New York, the Sackler Museum at Harvard, the Sackler Institute of Graduate Biomedical Sciences at NYU, and a wing at the Louvre all came to be funded by Sackler wealth. These institutions were not merely recipients of donations. They were, implicitly, endorsers of the family's social legitimacy. When the lawsuits arrived and the state attorneys general were building their cases, they were building cases against a family whose name was on the wing of the most visited art museum in the United States. That association does not prevent prosecution, but it creates a context, a sense of the family as pillars of civilization rather than as perpetrators of a public health catastrophe that the prosecution had to work against. The 500,000 dead require acknowledgement that goes beyond a number. The opioid epidemic did not kill uniformly across American society. It killed in specific places, in specific communities, in the specific demographic patterns that medical and sociological research has documented in detail. Rural Appalachian communities in the post-industrial Midwest where manufacturing jobs had disappeared and the economic conditions that make addiction harder to escape were already present. Native American communities. The epidemic reached these communities through a specific mechanism. Physicians who trusted the information they were given about OxyContin's safety profile and who prescribed it accordingly. A mining community in West Virginia did not become an epicenter of opioid addiction because of some pre-existing cultural disposition toward drug use. It became an epicenter because a sales force with aggressive quotas and marketing materials that minimized addiction risk was systematically targeting the highest prescribing physicians in every zip code in the country. The internal documents that emerged in litigation showed that Purdue's representatives were rewarded for the number of prescriptions written in their territories. The physician who was writing the most OxyContin prescriptions got the most attention from the sales force. The system was designed to maximize prescriptions, and it did. The communities that were targeted are still managing the consequences. The overdose deaths from prescription opioids that OxyContin helped initiate created a market for cheaper alternatives when prescription monitoring programs and reformulations made OxyContin harder to obtain. Heroin filled that market. Then fentanyl filled it more efficiently and more lethally. The synthetic opioid epidemic of the 2020s is downstream of the prescription opioid epidemic of the 2000s. The 500,000 dead from OxyContin are not the final number. They are the number from one phase of a crisis whose total cost is still accumulating. The $7.4 billion settlement spread across the communities affected, across the addiction treatment programs, across the prevention and education initiatives is not nothing. It is also approximately 1/5 of what the family extracted from the company in the decade before bankruptcy. The communities that were flooded with OxyContin will receive in total approximately 1/3 of the money the family made from flooding them. Richard Sackler, who drove the OxyContin marketing campaign as the company's president, and who sent the emails that emerged in litigation as among the most damning evidence of the family's awareness of what they were doing, has not been charged with a crime. He lives in Texas. His children, who inherited wealth, accumulated through the distributions that the litigation documented, have not been charged with crimes. The inheritance was their parents' money, legally theirs, transferred before the lawsuits reached the stage at which a court could have clawed it back. David Sackler, Richard's son, has given interviews in which he expressed regret about OxyContin's impact, while maintaining that the family did not intentionally harm anyone. He has described the experience of watching the family's name removed from institutions as painful. The family members who faced congressional testimony sat before cameras and said variations of the same things. They were not involved in the day-to-day operations. They did not know the extent of the problem. They had relied on the company's management to operate within the law. Kathy Sackler, Mortimer's daughter, said in testimony that she had never been part of any plan or scheme to mislead anyone. She said that her family was deeply committed to addressing the addiction crisis. She said she wished there was something she could have done differently. The testimony was not perjury. What was documented does not establish that she personally knew the specific facts that would make her statements false. The family's legal strategy had been, consistently, to maintain the structure in which the owners were separated from the operations in ways that made personal criminal liability difficult to establish. The structure worked. In January 2025, the $7.4 billion settlement received the approval it needed to proceed. The Sackler family agreed to pay the money over 15 years, with the largest payments up front. They gave up ownership of Purdue Pharma, which would be restructured as a public benefit corporation, directing its future profits to addiction recovery programs. They agreed not to place their name on future charitable gifts until the settlement terms were satisfied. The states accepted the settlement. The attorneys general who had fought the hardest, who had challenged the bankruptcy immunity provisions all the way to the Supreme Court, accepted it because the alternative was continued litigation against a family that had structured its affairs to make full accountability impossible, with the clock running on statutes of limitations and the ultimate recovery uncertain. The settlement was the best available outcome within the existing legal framework. It was not justice. The distinction between the best available legal outcome and justice is the space where 500,000 people died. The family that created the conditions for those deaths, that marketed the drug that started the epidemic, that moved $10 billion into protected trusts before the lawsuits could reach them, that used the legal system's complexity and the bankruptcy court's procedures to extend the litigation long enough for statutes of limitations to expire, that family is still intact. The name is off the museum walls. The museums are still standing, funded in part by money that came from OxyContin's revenue. The money is in the trusts. The trusts are protected. The family is worth approximately $11 billion. No one went to prison. The congressional testimony that members of the Sackler family gave in 2022 produced a record that is worth examining for what it reveals about the specific performance of accountability that the legal process required. 8 members of the Sackler family appeared before the House Oversight Committee. The appearance was itself the product of extended negotiation. Several members of the family had initially resisted appearing in person, and the committee chair had to threaten subpoenas before the family agreed to testify. When they testified, the format was a congressional hearing, which means each member gave an opening statement and was then questioned by representatives for periods of 5 minutes each. The format does not permit the sustained examination that a deposition or a trial examination permits. 5 minutes is enough time to ask a few questions and receive a few answers. It is not enough time to follow an answer with the follow-up that the answer requires. David Sackler, Richard's son, said that his family had not intended to harm anyone. He said that if he had known what he now knew, he would have done things differently. He said that OxyContin was one of many factors in the opioid epidemic. Kathy Sackler, Mortimer's daughter, said she was proud of the work she'd done in trying to help address the opioid crisis. She said she had not been involved in marketing decisions. She said she was sorry for the pain the epidemic had caused. Richard Sackler did not testify. His deposition in the Massachusetts Attorney General's case had been taken separately, under oath, and portions of it had been released publicly. In the deposition, he was asked about emails he had sent that described the expected impact of the OxyContin marketing campaign. He had difficulty recalling specific emails and specific decisions. His recollections were frequently general rather than specific. The email in which he described what would happen when OxyContin was launched, the one that anticipated the volume of prescriptions and described what the company should say when criticism arrived, was shown to him. He said he did not recall writing it. The email was signed with his name. The families that lost members to OxyContin were given the opportunity to speak at the bankruptcy hearings and at various points in the proceedings. They spoke. Their testimony was recorded in transcripts that are part of the public record. They described what it was like to watch a family member become addicted to a medication that a physician had prescribed. They described the specific texture of watching someone you love disappear into opioid dependency and emerge, if they emerged, as someone changed by what had happened to them. None of this testimony changed the settlement terms. None of it produced criminal charges. It was received into the record and became part of the historical documentation of what OxyContin did to the country. The historical documentation will be extensive. The court records from the Purdue Pharma proceedings are among the most comprehensive collections of internal corporate documents ever produced in American litigation. The 30 million documents that the settlement required to be made public include emails, presentations, sales training materials, and internal analyses that describe, in the company's own language, what it knew and when it knew it, and what it decided to do with that knowledge. The documentation exists. The accountability it might have produced, the criminal charges, the disgorgement of the transferred funds, the financial reckoning proportionate to the harm, did not materialize. The documents are the accountability. The documents are what the legal process produced. The communities are still counting their dead. Arthur Sackler, who died before OxyContin existed, who was legally separated from the main settlement, has his name on galleries at the Smithsonian and at Harvard and at other institutions that have not removed it, because his branch of the family settled separately and the circumstances are legally distinct. The distinction is legally real. In the specific sense that matters for museum naming rights and settlement terms, Arthur's branch and Raymond and Mortimer's branches are different entities with different legal histories. The marketing techniques Arthur developed are not legally his branch's responsibility for what those techniques produced when applied to OxyContin. The template and the application are legally distinguishable. Whether they are morally distinguishable is the question that the settlement terms, by design, do not resolve. The Sackler name that remains on the Smithsonian galleries is the name of a man who built the model. The Sackler name that was removed from the Louvre is the name of the men who applied it to 500,000 deaths. Both names are Sackler. The buildings that bear the first name still bear it. The buildings that bore the second name have taken it down. The money that funded both sets of buildings came from the same family and from the same pharmaceutical business. The walls that still show the name are not the walls that bear responsibility for what happened. The walls that took the name down are not absolved by having done so, and the communities that buried their children while the name went up on the museum walls and that are still burying their children while the name comes down did not receive justice in January 2025. They received $7.4 billion over 15 years, distributed by a public benefit corporation administered by people who were not involved in what happened. The $7.4 billion is real. The 500,000 dead are real. The $11 billion still in the trust is real. The rest is how we talk about it.